My name is Richard August, and I'll be your host. Our guest is John Grasso, an attorney with an office in Providence, Rhode Island. Mr. Grasso has advised several students accused of sexual misconduct under Title IX of the U.S. Code. And he's appeared previously on this program to discuss this issue. Welcome back to State of the State.
Thanks, Richard, for having me. Good to see you again.
Thank you. Our Constitution is under attack by those describing themselves as social justice advocates and progressives. The First, Second, Third, and Fourth Amendments in the Bill of Rights are being gutted. Free speech is no longer free speech on our campuses, where conservative speakers are often having their invitations revoked or being shouted down by leftist faculty and students. Hate speech is deemed to be a crime. The Supreme Court of the United States ruled some time ago that burning an American flag is an act of protest protected under the First Amendment, while a state court recently ruled that burning the rainbow LGBTQ flag was a hate crime. The right to carry and own a gun or weapon is being infringed every day in various cities and states in the name of public safety or common sense. There was a ban on so-called assault weapons signed into law in 1994 by President Bill Clinton as part of the Omnibus Crime Bill. Federally funded studies of the ban after 2004, two universities found no correlation between the ban and the rate of violent crime. Nevertheless, Rhode Island's governor and attorney general are determined to pass a ban on military-style weapons to address what they say is a public health crisis of gun violence, while the FBI statistics show that violent crime is decreasing. The Third Amendment is intended to protect citizens' rights to the ownership and use of their property without intrusion by the government. Rarely discussed in Supreme Court cases and decisions, the Third Amendment has more commonly been held up as evidence that the framers meant the Constitution to protect individuals from government intrusion into their homes, family lives, and personal affairs. Yet it seems every day legislation is introduced that infringes on personal affairs, of which the individual mandate under Obamacare is a good example. I believe that has been recently ruled unconstitutional by a federal court. The Fourth Amendment protects people from unlawful searches and seizures. This means that police can't search you or your house or your car without a warrant or probable cause. However, this protection is being eroded in the name of national security. We learned that under the Patriot Act, signed after 9/11, that government agencies were collecting phone conversations and email correspondence and storing them in large computers. I apologize for this monologue, long monologue, but the cases that we will be discussing with Attorney Grasso involve the due process protections under the Fifth and 14th Amendments to the Constitution. Mr. Grasso, would you begin with a review of Title IX for our audience, kind of explain what that's all about?
Sure. A long time ago, Title IX was initially enacted by the federal government to sort of equalize problems on college campuses. And what I mean by problems is that there was a gender inequality. So the football team may have a budget of $1 million, but a women's lacrosse team may have enough money to have a pizza party. That body of law, now bring it into 2020, is used to mandate certain actions by colleges and universities that receive federal funding with regard to gender discrimination. Where it applies in my universe is in the context of student misconduct cases. For example, an allegation of sexual assault on campus falls under the mandates of Title IX, which require the college to investigate and adjudicate those allegations. So these colleges and universities sort of become this mini system of justice, campus justice, in my opinion, without having the tools and the competence to do that sort of job, in order to make sure that their learning environment is free of any sort of discrimination, and it's an active learning environment. That's sort of the big picture of Title IX in the context that it applies to what I do for a living.
So Title IX, which I think was passed in 1972 and signed into law by President Nixon, was actually designed to try to equalize the disparity between men's and women's athletics.
Yes.
And how is it broadened into this other area? The law didn't really address this. Is it something where, for example, I guess the Department of Education, Federal Department of Education has issued regulations that broaden the thrust of this law, is that right?
And case law.
And case law, okay. So, as you said, the university gets to act as the police investigating, and the judge and the jury in coming down with a decision.
They have no choice but to act. If they're the recipient of federal funding, then there are consequences if they fail to act in this particular capacity. So when you look at colleges and universities today, I'm not sure you can find one that does not have an office or a division with a title that in one way or another encompasses this Title IX obligation.
Okay. I think you said in the last, we were on this program almost a year ago to the day with a retired Rhode Island College professor, Peter Allen, who had served on their disciplinary board. I think you said that a student accused of sexual misconduct under Title IX is not entitled to legal representation. You said, I think, your instructions are to sit and be a potted plant where the hearing is being held?
So if you look at the word representation in the context that we're used to an attorney representing a client, attorneys speak for their clients, they truly represent that individual. Colleges and universities will allow a student accused of sexual misconduct in a Title IX complaint to be their advisor, but not their representative. And that's where the potted plant analogy comes into play. So if we were at a Title IX hearing and there was a hearing panel assembled in order to hear facts and determine whether the student was responsible or not for the allegation or allegations, I'm allowed to sit with that student, and the student can whisper to me and I can whisper back to him. Otherwise, I have to be the potted plant. I cannot speak to the hearing panel. My role is very, very limited at that particular hearing.
Interesting. Now, there have been 2 U.S. federal district court cases in Rhode Island that bring Title IX into focus. The first is a case involving a Johnson & Wales University student that you, Mr. Grasso, wrote a My Turn op-ed in the Providence Journal on December 19th about. And again, I want to point out that you did not represent the students in either of the cases we're going to be talking about.
That is correct. I have really no personal knowledge of any of the facts beyond what I read in the decision from the U.S. District Court.
Okay. Can you summarize for us the case involving Johnson & Wales University and the student described as, I believe, James Doe or John Doe?
John Doe. Mm-hmm. There must be a lot of John Doe plaintiffs. The number of John Does in the U.S. District Court database is growing. I'm not intimately familiar with the facts of that case, but when you read the memorandum and the order that Judge McElroy issued, it captured my attention because it's like many, if not most, Title IX cases. Don't quote me on the specific facts of this case, but there was an allegation that the accused, John Doe, and the complaining student were involved in a substantive dating relationship for a period of time. They may have had intimate sexual contact with each other a number of times. I don't remember if it was then the 6th, 7th, and 8th time where the complaining student eventually came forward to say that it was non-consensual sex. What was interesting about it was that a lot of time had passed between those alleged incidents of non-consensual sex and when the complaining student's new boyfriend made the complaint, not the complaining student. Johnson & Wales investigated, and it was my understanding that the complaining student did not want to participate. And so
The female.
I'm assuming it was a female.
Yeah.
And then the complaining student, and so the investigation ended. And then a period of time passed when the complaining student and her new boyfriend, I'm assuming it was the same new boyfriend as the first time.
It could be another.
But it could have been new boyfriend number 2, then went and revisited this complaint. Johnson & Wales so-called adjudicated it and found the accused responsible.
Is there any indication that the young lady filed a complaint with the police if she says that on a couple of occasions the sex was non-consensual, which essentially I think what the newspaper or the article that I read said she told him no, and therefore she believed that she was raped on a couple of occasions where previously the sex had been consensual. Did she make a complaint, a rape case or a sexual assault case with police at all? Is it no indication?
I have no idea if she did, if it was a she, but in far more Title IX cases, the complaining student does not make a complaint to law enforcement. It is strictly confined to the college campus.
And not when we use the term sexual complaint, it's not always a rape thing. It could be some other sexual, non-consensual contact, right?
It doesn't even need to be contact. I've had cases of so-called dating violence, which is just misbehavior that allegedly arose in the concept of a dating relationship. It could be harassing. It could be coercive. It could be less than that. It could just be saying something that irritated the other person in the relationship who made a complaint. And because these allegations arise out of a intimate relationship, they fall under Title IX.
So the result of this hearing at Johnson & Wales was that they expelled the student, I believe, John Doe. So he was.
I believe so. Much more often than not, if a hearing panel finds an accused student responsible for what would constitute sexual assault, and the way we think about sexual assault, then the typical remedy or sanction is to expel that person from the school. Occasionally, there may be a period of a long suspension, and interestingly enough, someone should do a study on this, the suspension period may coincide with when the accuser is planning to leave the campus. So John Doe may be welcomed back in 3 years if the complaining student is going to graduate.
Or leaves the university for whatever reason. Now, Johnson & Wales University asked the court to dismiss the expelled student's case in this situation. And as I understand it, they would not even give the student who was accused a copy of the 18-page complaint and did not allow the accused to have an attorney with him. I don't know if that's in the pleadings that you have, but that is my understanding from the case. And he wasn't allowed to question his accuser. Is this common in Title IX cases that they would not allow you to question the accuser or see the copy of indictment?
I have never been involved in a Title IX adjudication that permitted the accused to confront his or her accuser. It has never happened. Is it common? So I would imagine that this particular student, the accused, was allowed an opportunity to have an advisor of his choice. Many of these students are reluctant to talk to their parents. They are offered an advisor who's an employee of the university. It could be, I think, interestingly enough, in this case, one of the hearing panel members, the jury, was in charge of, I don't want to sound negative, but it was like the head of baking. He baked cakes. And this is common for what we see in campus adjudications. So the student could have had that particular person as an advisor. Those folks are not competent to advise a student who's going through a Title IX process. They don't have any experience. They don't have any real training, although the schools report that they train these individuals. And then there was another case at Johnson & Wales that we haven't talked about, where in a motion to dismiss, the school had refused to provide any discovery, for lack of a better word. That word discovery doesn't actually exist in a campus adjudication. When the accused student, I would suspect through his legal advisor, said, can you show us what this training is about? And they refused to hand it over. And they were the only repository for that, so there was no other way for the accused to be able to look at, assess, and possibly confront the sort of training that these hearing panels are actually receiving. So going back to what I was saying, I think he was allowed to have an attorney, but like most students, probably just accepted an advisor or thought this is not that big of a deal, this is college, I can handle this myself, until they get right into the middle of the firefight and realize that they're just outgunned and they're in the wrong place. But by then it's too late.
Very interesting. Judge Mary McElroy ruled that the case could go forward to a jury, I believe. And as you pointed out, I think the university in these situations gets to act as the police and the judge and jury in that hearing environment. And there are people that are on that panel, maybe even the presiding person, don't have legal training. They don't have any idea of how to conduct a legal hearing.
The college or university will adamantly insist that it is not a legal proceeding. There are no rules of evidence that apply. Probably the most offensive aspect of it is that there's no gatekeeper of evidence, which is worth, I think, discussing for a moment. By gatekeeper of evidence, I mean the way these hearings go down is that the hearing panel is assembled and they will hear from the accused, the accuser. The accuser will come into that hearing panel and be allowed to say anything that he or she feels like saying. He or she can talk about old allegations of misconduct. They can bring in triple hearsay. I heard that, John Doe did this to Mary Smith. I heard that John Doe, when he was at another college, and just completely filled the room with with allegations of bad character. Now, John Doe is usually sitting in another room because we're not allowed to be at the same table, and he's listening to this through a telephone. And it isn't the time or the place. He has no way of defending that. And they hear, and the hearing panels hear this, and it goes on sometimes for more than an hour. If this was a legal proceeding, there would have been a gatekeeper of the evidence, and none of that irrelevant information that's not probative as to whether John Doe is responsible or not would ever be allowed to be put in front of a jury. So in other words, it's a free-for-all. And there's no risk or downside to the accuser filling the room with that sort of information, but it is terribly, terribly prejudicial for the accused because he is advised by me to just ignore it because there's nothing that can be said about it at that time that could possibly remedy or rehabilitate that particular situation. And eventually, I would imagine that schools, universities, and colleges will figure out a mechanism to filter this information or this input. But as it stands right now, if we have a hearing tomorrow, we never know what we're going to hear until it's already been said.
And I think you pointed out in this case that the accuser's boyfriend is actually the one who filed the complaint. On 3 months after the complaint was initially filed, that he made the complaint on behalf of his girlfriend.
So anybody can go into the Title IX office and make a report of a possible violation of the Code of Student Conduct. Then the school's mechanism, the engine starts up, and that's why the first instance, it terminated without a complete investigation, because ultimately the alleged victim refused to participate. So in a typical case where there's only 2 witnesses to an event, without the alleged victim going forward, then the school can't really prove its case. But once the complaining student makes that complaint, he or she can disappear. And there will be a hearing, and he or she does not have to come, and the school will adjudicate that to finality without ever having an opportunity for the accused or anyone else to ask the accuser a single question.
Let's talk about the second case involving a Rhode Island school of design, a student referred to as Jane Doe. Again, the Doe family seems to be
Big
involved
family.
in a lot of cases. Now, this is unusual because this event of sexual misconduct or sexual assault didn't even occur in the United States. It occurred in Ireland. Can you summarize a little bit about that case for us? Or?
Well, the RISD case is interesting because the RISD case is not a Title IX case. It's a tort case. It's a case that was brought, I think, on the legal theory of negligence and I believe premises liability. And if I recall the order that was issued by Judge McConnell, there was a motion for summary judgment that was filed by RISD, and he granted the motion for summary judgment on the premises liability theory, but allowed the negligence theory to go forward to trial. And I would imagine the theory in this particular case was that RISD had secured some housing, lodging in Ireland for its study abroad program. And on the first day when the students arrived, there was a report of a sexual assault on a RISD student, Jane Doe. And Jane Doe is now suing RISD for its negligence, its participation in procuring housing that was substandard and didn't provide adequate protection for the RISD students.
So to be clear, this is not a criminal proceeding against the alleged perpetrator. It is a civil action against the school for not properly caring for the student that was assigned, or I guess that they don't assign them, but who had signed up for study abroad in Ireland.
Right. I mean, to dumb it down, if this particular incident occurred on the RISD campus in Providence because they failed to replace the carpet on the stairs and Jane Doe fell down the stairs, then she would sue RISD on a negligence theory. This occurred in another country, and the alleged negligence is that RISD secured housing that didn't have proper locking mechanisms on the doors to the bedrooms, and as a result, someone was able to gain access to Jane Doe's bedroom and perpetrate a sexual assault. It couldn't be a criminal case in the United States because the act occurred in Ireland. But what's interesting about this case, not from a Title IX perspective, is that when we look at jurisdiction and then the federal government has to look at the Rhode Island state law, that Judge McConnell said Rhode Island law applies and that it is possible that based on these facts, a jury could find the school negligent.
Right. So his ruling really says that with respect to that negligence issue, a jury would be the finder of facts. They're the finder of fact to determine whether or not this actually occurred.
Correct. Now,
And-
there was a Title IX component to this. Immediately, actually, I think if you look at a timeline of the events in that particular case, the victim made a Title IX complaint to RISD. But reading the decision, I believe, it stated that the accused admitted responsibility. So that particular accused student did not defend himself. He just admitted to the Title IX violation, or the violation of RISD's student code of conduct. And I believe he was suspended for 3 years
Yes.
as a result of his admission.
Yes, and Jane Doe filed a complaint requesting a no-contact order and asked that John be removed from the program. He was ordered, this is while they were still in Ireland, I guess, and he was ordered to leave and suspended from RISD for 3 years after he took responsibility for the assault, which is maybe a legal issue or definition. Is assuming responsibility for an act the same as admission of guilt? Or is it a kind of a fine line?
I suppose, depending on how you wanted to define an admission of guilt and admitting responsibility, I'm guessing that the accused student in that case simply said to the school, I admit that I am responsible for violating the student code. I can't imagine that he said, I perpetrated a rape of this particular person while I was in Ireland.
Yeah. Yeah.
You had mentioned that they immediately removed the student from the program and sent him, I would assume, back to the United States. So colleges and universities have a variety of remedial measures that they could take immediately upon a person making a complaint. This person hasn't been proven responsible. And not so long ago, schools were quick to just remove the accused student from campus immediately, in the middle of exams or right before exams. Fortunately, that is not the norm anymore. There are protective orders put in place, and there is a no contact order that's typically put in place between both students, but it only goes in one direction usually, and the accused student cannot have contact with his or her accuser. That could be a little bit complicated when it's a small campus, but the schools police that, and that's that's usually available to the school, and they always, or more often than not, will put that into place.
Given that this is a tort case or civil action, the burden of proof would be a preponderance of the evidence, where in a criminal case it would be beyond a reasonable doubt, a higher standard. So
Correct.
there's, well, unfortunately, we're really almost out of time. It seems to me that it boils down to in a way to, we talked a little bit about this a year ago, to what extent does Title IX extend beyond the campus? I mean, we had one of the hypotheses that I put forward was 2 students who leave school for summer and they go to the same place for a summer job, and they end up being sexually involved, and one of them comes back and then complains to the school. At what point do we draw the line?
I would argue under that scenario that is not a Title IX problem. But if the 2 students went on a field trip, I'm dating myself,
yeah,
or if they participated, for example, the RISD case is interesting on that point because it proves that the college's jurisdiction on Title IX issues spans oceans.
Mm-hmm. Very interesting, and we want to thank Attorney John Grasso for coming on State of the State to discuss this. Perhaps there'll be other cases that we will talk about in the future. Thank you very much for joining us.
I hope we will.
And thank the audience for watching State of the State.